Продовжуємо засідання.
Let's resume our meeting. Please invite Ivan Oleksandrovych Kravchenko.
Доброго дня.
Good afternoon.
Розглядається питання щодо відповідності
We
кандидата на
will
посаду
consider the compliance of the candidate to the position of head judge with the criteria provided for by Article 8 of the Law of Ukraine on High Anti-Corruption Court. In this hall, there is Robert Brookhuizen, the head of the CIA, John J. O'Sullivan, Jessica Lott Thompson, Norman Aas, Mary Butler, Gabriel Yotkaite, Roman Kedis, Irina Kubacka, Alexei Omaryan, Roman Sabodаш, Ruslan Sidorovich, Sergei Chumак, Helena Savchuk.
Перед початком розгляду питання, колеги,
Before we start discussing
я з Кравченка Івана
this file, I would like to inform that I know Mr. Kravchenko. Back in 2009 or 2010, he was a student at the educational institution where I taught. But since then, since 2010, we never communicated, we never met, and I am totally unbiased, but for the purpose of transparency, I would like to disclose this.
Ви маєте право заявляти відвід,
You can file a motion, recusal, express your objections, and express your thoughts. Will there be any recusals? No, not recusals. Thank you. The rapporteur on your file will be me, so I will make a short intervention. Kravchenko Ivan Oleksandrovych contacted the Commission with the application to participate in the competition to fill in the vacant positions at the Hague as someone who corresponds to the Article 28 of Ukraine on the judiciary and status of judges. And he was admitted to the qualification assessment. He passed the qualification assessment. He got the following result: cognitive abilities 45, knowledge of the statehood 40, practical assignment 123, and overall he received 332.91 in 1211. He graduated from the Ukrainian Academy of Banking of the National Bank of Ukraine and got his specialization in legal sciences. He also graduated from Kharkiv National University of Interior and got the scientific degree of the PhD, Doctor of Legal Sciences. He was also given status of professor of the Department of Administrative Law, and he worked in different capacities. He was a professor, in particular in Sumy National Agrarian University. He has his attorney license since the 25th of July 2018. Would you like to add something? No, everything is correct. All right, thank you. So I'm passing the floor to Mr. Robert, please.
Thank you, Mr. Chair. I please pass the floor to Gabriela, the rapporteur.
Thank you. So, hello, Mr. Ivan Oleksandrovych. Congratulations to you that you came to this stage, to this interview. First of all, I would like to emphasize that we are discussing only the materials that was gathered by our secretariat and other provided by a lot of institutions, and also you participated in this process by giving us answers to our questions. And if I repeat myself in questions, don't be afraid to repeat your written explanation as well. And also, I would like to ask to be very concise in your answers because we have time limits, and therefore we want to be precise in keeping them. So first of all, I would like to ask about your motivation and about your experience. As I understand from your curriculum that your main sphere of experience is administrative law, yes?
Ну, це тематика, за якою у мене
Well, it's the topic
докторська дисертаційна
on which I wrote my PhD thesis. And starting from 2018, I got interested in criminal law as well. And so I started having new scientific articles in this area.
How do you think your experience will benefit the work of HAC if you will be successful in this competition?
Запитання.
Thank you for the question. I would like to say that scientific activity in general develops very important skills. In my opinion, such skills as deep legal analysis, also independent thinking process, impartiality. Also, academic activity includes a systematic analysis of huge volumes of information. And as the articles are prepared or during the participation of scientific events, the academic activities make you learn how to substantiate your conclusions, your position based on law and not based on assumptions. I think it will be useful. It's useful for a judge. Also, a scientific community in general makes you challenge well-established positions, and it also makes you analyze instead of using certain models or patterns. And it educates and it teaches not to be afraid of complex legal positions. And I think all of these things are important for a judge because, first of all, it will strengthen the resilience if there is social pressure or information pressure. Secondly, it will allow to administer justice based on law and not someone's expectations. Also, during my academic activity,
to be more concise, because you are just answering as a real scholar, and we just want to be more.
Я так розумію, у нас є сигнал повітряної тривоги, да?
As far as I understand, we have an air raid alert. Dear colleagues, we've already had such experience. We will discuss it once again, but we previously decided that we would continue the meeting and just monitor the level of threat. And if there is a serious threat, we would announce a break. What are your thoughts on that? Should we follow the same procedure?
Yes, Mr. Chair.
Члени комісії.
Dear Commission members, Ivan, your decision. Let's do as you suggested. And dear representatives of the Secretariat, no objections. All right. I will then follow the events. If there is information about more serious threat, we will react. So let's continue.
So thank you. And you said that you are interested in criminal law since 2018, yes? And maybe you have some articles or experience with the analysis of hack practices, high anti-corruption court practices. Maybe you used them in some articles.
Ну, в 2018 році я почав
Well, in 2018, I started by drafting comments to the then legislation then in force, the Code of Criminal Procedure.
На сьогодні можу як приклад
And
привести
currently,
публікацію
I can give an example of my latest publication
фазі Scopus.
in the Scopus scientific base. My colleagues and I started working on it in 2024. The process was quite lengthy, and we analyzed usefulness of artificial intelligence in
Just asked about the practice of high anti-corruption court, not about digital intelligence in the administration of justice. So please be very, not general, but very concrete in answering the question.
Ну, справа в тім, що ця стаття була спрямована на
Well, that article was in particular about anti-corruption activities, and it was related to the activities of the judiciary. As to specific cases of the anti-corruption court, I don't have scientific research pieces about it specifically.
Thank you. And another question, your main activity, as I understand, one of the main activities is lecturing. So will you proceed with lecturing if your participation in this competition will be successful?
Дякую за запитання. Воно
Thank you for the question.
досить складне, але в той самий
It's
час
quite
і,
complicated,
як на
but
мене,
the
є
answer
очевидно, що
is
навантаження
obvious as for me. The workload at the High Anti-Corruption Court is very big, and they have a very important and a very difficult category of cases. And I understand that if I pass the selection successfully, I will have to work at the Hague only.
Thank you. So I would like to proceed to another block of questions related to your legal practices and income from them. As we understand from your, not from your declaration, when we look through in the Unified Register of Advocates, it indicates that you received a certificate of advocate in 2018, yes?
Так, саме у 2018 році,
Yes, in 2018,
в серпні місяці.
But
in
you
August.
indicated this information not directly, but we can find this information indirectly because you are stating that you are working at the Andrei Petukhov law firm and the Urait law firm. Yes, you are working in these firms.
Дякую за запитання. Так.
Thank you for the question. Yes.
Але, ну, фактично на сьогоднішній день
But as of today, actually after the start of the full-scale invasion, the Urait association hasn't been actively working. It was established before the COVID pandemic, and then the full-scale invasion happened. So the company stopped its development. And as to the Andrei Petukhov law firm, I keep working there, and I sent a copy of my contract to as a response to your second request, and I sent the number of working hours per day, and it was 1 hour per day.
And you think that it's normal to be a partner in the firm, give legal to make legal practice and be active only 1 hour in the firm before legal.
Ну, справа в тім, що
Well,
у мене
in fact,
адвокатська діяльність, вона
my attorney's activities are optional to me.
взагалі метою отримання мною
It is my second job. And the reason why I got my attorney's license, it has never been earning income.
основного виду діяльності.
It was not my main area of activity. It was meant to be one. And since 2017, at our university, a different person was the dean of the faculty, and they encouraged the actual academicians to get an attorney's license in order to have some practice, in order to gain hands-on experience. And as I stated in my explanation, we have a legal clinics where such academicians as myself started providing consultations, and that the faculty benefited from it. The prestige of the faculty benefited from it because students also benefited from it because they gained practical experience, and once graduated, they had some background already.
So, as we see from your declaration, that you indicate some small amounts of income from this Andrei Petukhov law firm from 2020 and until 2022. But you just said that you are still working here, so you have no income since 2022 from this Andrei Petukhov law firm.
Ні, дякую за запитання. Ні.
Thank you for this question. No, I haven't had income since 2022 until now. Since 2022, since the onset of the full-scale invasion in our borderline oblast, Sumy Oblast.
Це прикордонне місто, і на сьогодні
the demand was low, and the demand for any services is rather low and has plummeted since the onset of the full-scale invasion. And it also reflected in the activities of the law firm. And since 2022, I have been on sort of holiday at my own expense, and I don't have a need to be there.
So, as I understand from your explanations and from the information provided to us, that you appeared in multiple court cases as a defense lawyer representative. So, explain, please, how you could represent clients in multiple court proceedings while receiving almost no income. Did clients pay fees to their advocatization right or Andrei Petukhov law firm in these cases?
Саме вам надати інформацію саме в цих фірмах?
I can provide the information regarding services provided for these law firms, or even before I started being self-employed.
No, I just want to ask if you were representative of in several cases. You made it pro bono or just before acted as a member or part of these law firms, and the fees goes directly to these law firms?
Дякую за запитання. Так,
Thank you for
декілька
this
справ,
question. Yes,
я здійснював як адвокат.
a few cases were considered by me as an attorney of these firms. And one of the examples,
Чому? Тому що
all those cases were indeed pro bono because we had a category of clients. A friend of mine, a veteran, turned to me. He had a traffic accident, and I represented him in the court, before court. Another case, or other cases, that is, I would represent CSO members pro bono, on a pro bono basis. And what else? And I actually sent it to you, a contract that I managed to get following your request on March 7th. I sent you a copy of a contract when on a pro bono basis, when I represented a client who was later acknowledged to be incapacitated. So I stated that in that case, I did not charge that person.
So can we make the conclusion that all the work you perform as an attorney or as a representative in some cases, you made pro bono just to gather the experience and to use these materials in your training procedures, yes?
Так, саме так. Я вам
Exactly so, yes. And I already mentioned some tasks and some categories that I created thanks to this experience.
So, as I understood also that these firms, URIT, are composed from the shares that are held by 3 members, including you and Andriy Petukhov, yes? And now I would like to go to the defense of the same Andriy Petukhov. He defended dissertation in 2021 when you already were in the business activities with him, and you were an opponent in this defense. Yes?
Так, саме так.
Yes,
В якості
that
офіційного
is right.
опонента.
I was his official opponent.
So, how can you explain that you received income from the law firm associated with Petukhov, and you had common business, and you participated in the defense in very important position as an opponent? Thus, in your opinion, it makes some conflict of interest?
Дякую за запитання. Як я вже зазначав, то ми це питання тоді дослідили разом з науковим керівником і вченою радою університету. А на той час...
Sorry, no translation. Interpreter, hello?
Українському чую.
Translation.
Немає? Hello.
Or testing.
Yes.
Yes.
No.
I had a technical issue switching to channels. I apologize.
From the beginning.
Як я вже зазначав, то
As I mentioned,
питанням звертався до наукового керівника.
I turned to my scientific advisor with this issue, and we studied this issue with the scientific board. At that time, there was a norm, and I indicated them in my explanations. Point 15 of the order of academic titles granting, adopted by the Cabinet of Ministers of Ukraine. There are requirements and prohibitions regarding the official opponent there, and so point 18 of that order, the only barrier for me or any candidate to be an official opponent was if the person worked in the same structural division as the author of this thesis. So that was a clear prohibition. Beyond that, if those two individuals worked in different structural divisions, they could serve opponents. And therefore, we got familiar with the prohibitions. We arrived at the conclusion that I could be the official opponent, and I was able to give an objective evaluation of his work.
Yes, I understand, but you are talking and explaining the scientific aspect of the question. I am asking about the common business and income from a person that is defending thesis and in which you are opponent, not in the different scientific divisions in the university as such.
Я розумію,
I understand this.
на той момент
Back then, at that
не
moment,
було заборони
there was no
щодо
prohibition
наявності таких відносин
to
між
have
опонентом
such a relationship
власне більшого заборони
for an official opponent of,
у
and
випадку,
the
коли
author of the thesis.
опонент працює
There was only a prohibition, an explicit prohibition, to have an official opponent to work in the same structural division that the author of the thesis, and some other prohibitions regarding the officials of the Ministry of the Education, but I'm not one of them.
So then I will ask from another side, how would you act as a judge in such situation when you see such situation among the, for example, your panel colleague judge and the defense party, how you will act in the same situation? Professor Judge, your colleague in panel was opponent in the defense of the accused person in the high anti-corruption court. Is this the conflict of interest? Is there a obligation to make recusal for such judge?
Треба розібратися, чи є тут приватний
Well, we need
інтерес,
to understand where, if there is a private interest
якою може
in
виникнути
this situation.
потенційний конфлікт інтересів.
If a conflict of interest may really arise, if there is a private interest in the first place,
відносини, які склалися між
and the relations
всіма особами, якщо
that are there between these two parties. Let's take my situation. So with Petukhov Andrei Yuryevich, we have exclusively business relationship, and Any material or any other type of dependency is absent in our relationship. I am not dependent on him.
Even though you are receiving the salary from him.
Скажімо так, дана зарплата і даний трудовий
My salary that I get from him and our contract, work contract that we concluded for so that we can cooperate was done with an aim to earn income for the firm and for myself. And it was not the main source of my income, as you can see from the amounts that I got throughout my period of employment there. The amounts are rather insignificant, so calling this a leverage on his part or a dependency on my part or a source of bias on my part in the situation, I don't think so.
So thank you. And now I would like to ask a little bit about the funds related to the purchase of an apartment and the car. And first of all, in 2014, you acquired an apartment in Sami. You explained that the purchase was funded by your parents. Do you confirm that?
Yes, I confirm this.
As well as for the car that you purchased in 2011, yes?
Я вам зазначав відповіді, що не
As I
я
stated in my explanation, I didn't purchase the car and I provided the contract, a purchase and sale agreement where the customer is my father. What I did was I registered the car because my father is a doctor and he has many patients. And it is really hard to postpone appointments that people have scheduled, the patients have scheduled with him. And because my schedule was less tight, we decided that it would be a better idea if I registered the car, so he should have power of attorney for me.
Yes, thank you. And you also indicated only the income of your parents starting from 2013. Maybe you can some additional information until this time. What was the income?
Дякую за запитання. Так,
Thank you for your question. Yes, I stated in my first response that in order to get information before 2013, I needed to get a certificate and wait for it for 10 working days and then collect it in person. And it seems to me that on February 26, I sent you, as an additional piece of information, a certificates containing the information regarding the fact that until 2029, I don't remember, that documents were archived or eliminated, and from 2010, you can find information about my parents' income there. And this is the only piece of official information that I could find.
Maybe you can provide very briefly information about business activities of your parents, what they are working.
Так, звісно, дякую.
Sure, thank you. Since 1996, they have been private entrepreneurs. Second group, they are dentists. My father
з
operates alone
найманими працівниками, а мати проводить
with,
діяльність, вона ще має найманих працівників лікарів.
without hired employees. My mother has hired employees, one therapist and another orthodont. It maybe from 2012. It was the first hired employee. She hired her first employee in 2012, if I remember correctly.
Наявними лише медсестрою та відповідно санітаркою, ну, молодша медична сестра, можна так сказати.
And yeah, some junior medical personnel is employed. And as I provided another certificate to you yesterday, I sent you the most recent updates on their pricing.
So the next block of question is related to your living expenses, and as you explained that you, for example, in 2018, you declared, you and your wife, for two persons, you had 75,000 hryvnias per year just for your expenses. You think that it is enough? We understand that it is minimum average expenses per month, but how could you explain that this amount is enough for you?
Ну, дякую за запитання. На той
Thank you for
час
this question. Back then,
цього, в принципі, було
it was enough, and I also provided you proofs for that period. And again, my parents assisted us in payment of utilities, but Privatbank application allows me to extract information currently only until 2023 or maybe 2021. But I provided you as a proof some receipts of payments in 2025. So utilities were not paid by us. We only had to try and live on a budget that remained and satisfy our needs being on that budget. My wife at that time also had some insignificant income. I don't remember the exact amount, but it did not exceed the savings that needed to be declared. So they were insignificant. And additionally, my salary was used to maintain us, and my mother-in-law works in Italy, and from time to time, even before my wife and I met, she would assist her daughter again with some insignificant sums in 2025. I provided you proofs, and because her income was quite significant, or that is, a gift was significant, 50,000, the gift to my wife from her mother. But mostly, it's under 100, 200 euro once in 2 to 3 or maybe 4 months. So this is how we managed to live on that budget.
And also in 2018, you indicated that you have 2 foreign trips to Czech Republic and to Italy. So how these trips were organized and what expenses you personally covered?
Дякую за запитання.
Thank you for this question. As I indicated, our trip to the Czech Republic was a part of a summer legal school in forensics, and I provided you a copy of certificate. This is the only thing that I have from 2018 to prove that in that period I was in the Czech Republic, enrolled in that training, and the hosting university provided for our accommodation there. There was a group of different academicians from Ukraine and elsewhere. So the university also provided for accommodation, meals, and some entertainment, and I was really surprised and pleased by that experience. My costs in that trip were to pay for the bus fare, and I explained that my parents gave me a lift to the bus. Then I took the bus, and Pan Bus was the title of the firm, I guess. So one-way ticket cost about 1,100 hryvnia.
Yes, and what about Italy?
Italy, so that trip was covered by my mother. That is my mother-in-law, because we gave her a visit there to get to Kiev. My parents gave us a lift to Kiev. Then airplane tickets were bought by my mother-in-law, and we lived at her place. We stayed at her place. She has a sort of farm, and she has a small house in her private ownership where we stayed during our trip. And the way back, it was covered by my mother-in-law.
Coffee in some cafeteria, nothing, just mother-in-law and in their place. You bought not?
Ні. Ну, ми, звісно, ні. Вибачте. Так.
Of course, I'm sorry for the misunderstanding.
Я не досить часто.
So because I don't really travel too often, and my mother-in-law was got her bearings in Italy, and she could buy us tickets to some tours and excursions to Florence. But our stay there was covered by my mother-in-law. And it was, so to say, an opportunity for us to get each other more closely. At that time, my wife and I were still not married, and it was on the verge of our marriage.
And what your mother-in-law is working in Italy? What is her activities there?
Знову ж таки, наскільки я правильно розумію, вона...
If my understanding is correct, she takes care of a household. There are people who have big house, have a big courtyard, and my mother-in-law takes care of the house, in part of the courtyard, to make sure all of it is maintained and neat and clean.
деяких моментах я точно
So
просто
this
сказати не
type
можу.
of activities, and I cannot give you more details.
My last question is related to your wife's income. You said that your wife have some small income, and but in your declarations there are no indications about it. So how can you explain such situation?
Я, здається, я не казав, що вона має незначний дохід.
I didn't say that her income was insignificant. I could write that on her account there was a sum which, according to an ACP explanations, is not subject to declaration. I provided the extract from her account as of December 2025, and if I'm not mistaken, there are 54 or 55,000 hryvnias in the account, and including the transfer from her mother in the amount of 50,000. My wife had entrepreneurial activity as a private entrepreneur. Unfortunately, I do not recall the exact date, but it was approximately until 2018. 2018, approximately, maybe 2017. And that's all. After that, she stopped doing it and stopped getting the income.
If I understood you correct, that in your opinion, the Ukrainian legislation does not oblige to declare small amounts of money if they does not reach some kind of threshold of your relatives, of your wife?
Ну, у випадку моєї декларації 24-го,
Well, in case of my declaration for 2024 and 2025, I have already submitted the declaration for 2025, taking into account the mistakes I made previously. So, as far as I remember, threshold for declaration is the savings that exceed 51,000 hryvnias. And on her account, there were 54 or 55,000. And that's why I didn't declare this sum.
So you think that your wife or you cannot declare the, for example, the child money, as we call in Lithuania. I don't know how it in Ukraine it's called, the benefit from child money.
Якщо я правильно зрозумів, ви
If I understand correctly, you probably mean the monetary assistance during a birth of a child, which is paid until the child reaches the age of 3. I described in my written answer that I failed to indicate it by mistake, and the sum wasn't exceeding the threshold. There were 860 hryvnias every month during 8 months. And later, when I read the NACP explanations as to how to fill in the declaration, I understood that in that case it was my mistake.
Thank you. I have no more questions.
Thank you, Gabrielle. Questions on this side? No. Norman? No. Back to you, Mr. Chair.
Дякую.
Thank you.
Також маю кілька питань.
I also have a few questions. We partially touched them, but I will clarify certain aspects. Starting from 2019, what car do you use? Thank you for the question. From 2019, my parents had two vehicles, Honda CR-V and Honda Civic. I was not asking about it. I periodically used either the first one, either the second one, or the second one, depending on the needs and depending on the availability. So you used Honda CR-V or Honda Civic? Yes, if I'm not mistaken. So you didn't use other vehicles. There were only these two ones available. All right. As you indicated, the Honda CR-V belongs to your parents. Could you explain why in the sale and purchase agreement you are indicated as a buyer? I provided the agreement and the buyer is my parent, and I just registered the vehicle. But you are indicated, so you are indicated as someone who registered. Yes, I provided the agreement, and the father is the buyer. All right. What about the Subaru Outback vehicle? This one was bought by my father as a replacement for Honda Civic. In 2020, he sold the Honda Civic and bought the second one, and you never used it. I did, but not too often. But before I asked another question. Starting from 2019 was the question. Yes, excuse me, I didn't understand correctly. So yes, before 2020, there were Honda Civic or Honda CR-V, and starting from 2020, there were two vehicles I could use, Subaru or Honda CR-V. Okay, how can you explain that according to the Ministry of Interior information base, in 2020, there was an event. You detected a damaged glass in your own vehicle and contacted police, and your own vehicle was Subaru with the same number you provided in explanations. It happened during the night. So during the night, you were calling and explaining it. Thank you for the question. I didn't make the call during the night. The damage was detected by my father, who in the morning was going to his workplace and noticed that the right glass of the Subaru vehicle was just hanging, and he called me, said that I am on my way to my work and please deal with this. I called the police, and it became clear that there was a group of people who did this damage during the night. Could you please explain why, according to the data of the police, it is indicated that you are the owner of the vehicle? Legally, and actually I was never the owner of the vehicle. I called them and I submitted an application, and to simplify the communication, we could understand that it wouldn't bring any results, but still it was necessary to register such a fact. And for the purposes of communication, and where do you live? Where did you live when that event happened? We live 600 meters away from the parents, so you could just come closer. Yeah, it takes 6 minutes for me to come to my parents. All right, 2025. A similar situation happened, but in Lviv. And it is also stated in the data of the police that you, as the owner of the vehicle, and I quote, owner of the vehicle, applied to the law enforcement with the same statement that this same vehicle was damaged. I will explain everything. If I'm not mistaken, we went to Lviv for several days because my mother-in-law came and my parents provided the vehicle for us to go to Lviv for 2 days and then to come back. And when we spent the night in Lviv, so first it was my father who called me to Lviv and said that for some reason Lviv police calls me. Look at the vehicle. So, of course, you used the vehicle. Yeah, that's what the situation. And those who damaged not only my vehicle, but other vehicles as well were caught. How often do you use this vehicle? Well, for example, over 2025, as indicated in declaration, I used the vehicle maybe 50 or 60 days overall. And in 2024, I virtually didn't use the vehicle. Do I understand correctly that your father has 2 vehicles right now, Subaru and Honda? As far as I remember, Subaru belongs to my father and Honda belongs to my mother, according to the registration. Your mother has a driving license? Yes. Is she driving? Rarely, if needed.
Далі, блок інформації з правоохоронних органів.
The next block of information came from law enforcement. Could you explain
Помилкова така інформація.
whether it was a mistake? It's possible as well. It is indicated that Sumy District Police Department got a call, got a statement from the city military enlistment office stating that you avoid military conscription, and it was 2024, end of 2024, and you were called as someone who avoids military service. Do you know anything about it? Thank you for the question. I became aware of it during the review of the results of the special check. I was surprised as well, because the last military medical commission assessment was in 2023, but I appeared before the military enlistment office every 3 months to update my data about my place of employment and to provide the new fresh certificate and to get a certificate from the military enlistment office confirming that I am a professor and what is your current status? I have a deferment based on the fact that I'm a professor. All right, and this temporary exemption was in force back then as well. Yes, of course, it was probably a problem of communication with the office. Yes, I come to them every 3 months with the originals of the documents that I have to update the temporary exemption. All right. Also, could you please explain the circumstances, reasons, and motives? In 2011 and 2013, you were brought to administrative liability under Article 130. There were such facts, yes. Okay, could you explain your relation to those offenses? Why it happened so? Did you draw some conclusions, learn some lessons? Yes, of course I did. Both violations happened because of my lack of experience in the procedures and the way we should communicate with the representatives of state inspectorate. I do not use alcohol, consume alcohol, and back then
постійними розмовами, так, це представництво інтересів
there were constant
і будучи викладачем, також я постійно
as a professor, I had to make statements, and I didn't know
засіб, яким я
that
користуюсь, коли в мене відбувається запалення,
thing I was using during
для того, щоб воно показало наявність алкоголю.
for treatment contains ethanol for the inspectors to make a conclusion that I was consuming alcohol. It happened both in 2011 and 2013, yes. And I was sure that everything would be all right, but we checked. I was surprised and I asked whether we had to go somewhere. I showed the spray to the representatives of the inspection. They explained that it would change nothing, and you're explaining what happened in 2011? Yes, it was in 2011. In 2013, after my previous experience, I participated in the court hearing and I explained the circumstances. I never consumed alcohol. I was just using medicine against inflammation. So if you had such an experience in 2011, you kept using that same medication. Unfortunately, my doctor couldn't give an alternative. Do you recall the title of the medicine? Excuse me, no. Unfortunately, no. Okay. And did you participate in court hearings? Yes, I did. And later you could get familiarized with the text of the ruling. Well, I don't remember them, but I did receive them. Well, in the ruling for 2013, it's written that during the court hearing, the person acknowledged the guilt and asked not to apply sanctions. How does it correlate with your explanation? I explained that yes, it happened. I was stopped, I was checked, and I could see the result. I also confirmed that I didn't undergo further examination. So I didn't object that this happened. It wouldn't correspond to the reality. So I explained what happened. So we can assume that there are some objective signs, but since judging by your explanations, there are no subjective arguments. Didn't you try to challenge the decision to provide some medical proof? The composition of the medicine which gave that effect. You know, back then I didn't have this thought. I didn't think to act like that. Unfortunately. All right. And another question. Let's go back to the administrative practice. There are several decisions of Zarechny District Court in the cases about administrative offenses. You were brought to disciplinary to administrative liability. You challenged these rulings, and as a result, the rulings were overturned. You were more decisive in those cases, yes. Do you recall the latest case? It is of February 2020. What were the circumstances of the protocol? What was your position, and how did you challenge the actions of the patrol police? I remember the events of 2018, and I remember other events either from 2019 or 2020. You know, it happened in either in December or in 2019 or January 2020. We most probably talk about the second. What were the circumstances briefly? After a working day of my father, we were visiting construction stores. Let's start with the objective side of the offense. Yes, it was evening, so it was dark, and there was snowing or raining, and we were driving. At some point, I noticed that there was a patrol police vehicle behind, and I realized that it's because of my actions. I stopped and were allowed where it was allowed. The patrol policeman first said that I didn't let a pedestrian cross the street. I answered, please provide the video, and I will present my license, and if it's true, we'll draft the protocol. We looked at the video, but the pedestrian wasn't even closer to crossing the street. Then they said, you didn't stop at the stop sign. I asked for a video proof again. If I made an offense, I would agree. So they showed the video, and on the video, in the video, we could see that we could not identify the stop. We could only judge that there was a bus stop by the vehicle lights, and all right, it's clear. I turned and I mentioned that I stopped twice and they required the driving license. I called the police. All right, thank you. I understand the situation. It's a standard one. All right, and I have the last question. We mentioned it today already. In your declarations for 2019 and 2024, you didn't indicate any real estate item in section 3. Why so? It's impossible that you lived nowhere and you used nothing. Maybe it was 2018 and 2024. Yes, maybe. It wasn't conscious. I didn't want to conceal the fact that I was using some property. It's just that the apartment I lived in and I continue living in belongs to my father, and I provided the sales and purchase agreement. And I live there free of charge, and I indicated the actual place of residence, which corresponds. Yes, but about section 3, it was a mistake. I wasn't concealing everything. All of the mistakes were taken into account, and in the declaration for 2025, I mentioned it. All right, we can see that in the declaration. So it was a mistake without no intent to conceal. Yes, and you indicated the address of residence. Yes. All right, thank you. No questions from me, dear colleagues. Yeah, please. A few short questions. Ruslan Sidorovich, member of the Commission. Could you please comment on what seems to be a non-standard picture? You are a professor, you have an academic background that we could see. You are a beneficiary of attorneys association and another company, but as a partner of that law firm, you do not participate in court hearings. At least we do not see that. Also, in this section related to the cases you are proud of, Well, you are not a candidate to the Academy of Sciences, but a candidate to a position for a position of a judge. So you haven't provided any practical court case that you would handle, and it's not really typical for a practicing professor. Do you have any practical activities as a lawyer? Thank you for the question. Actually, my activities as an attorney is optional, not a principal one, and my goal is not to get profits through this activity. And so I applied as a professor, as a scientist, and I decided that if I present my candidacy as a scientist, not as an attorney, indicating cases where I represented interests in the court would be irrelevant. Moreover, the number of such cases is small. So experience of practical involvement is modest. Yes, not too big. Well, I think that doing all at once science and real practice it's good. And you say these activities were optional, so there was something, some attorneys' activities, and it didn't bring any income. So this law firm, you're a partner there, not only an employer, employee, and it's not typical. Usually partners to bigger or smaller extent still get something. It's not a charitable activity. There should be some income. Yes, I understand your position. It's not a position, it's I'm surprised. We established this company to have some joint activity, and since my activity as a self-employed person was also modest, so it was not hard for me to stop my activity as a self-employed to reduce bureaucratic side of it and join the activities of the law firm. The purpose of its establishment, well, we had plans to start involving it after we hire an assistant, after we hired new workers. So we signed the memorandum with the National Agrarian University with that law firm, and our students could have the practical courses there, and I invited students there, and we could find potential lawyers or assistants. Did they become real, not only potential? No, because the whole process that we were planning was suspended because of the pandemic. We were trying to get adapted to the new conditions, to the remote format, and then the full-scale war started, and it was we didn't manage. All right, and currently we even think about ceasing the activities of the law firm. Okay, tell us, please. You are the owner of corporate rights of your right enterprise and the LLC, the same title, the same people. Of course, it's your constitutional right. But what's the purpose of establishing two legal entities with identical titles with different legal form? You know, there were ideas about how it could work, but in any case, everything started with it as a law firm, and there are some nuances as to their activities. One of the partners suggested it. I do not object. There might be different grounds, but actually, his active activity had to lead to active activity of the company, and it didn't work out. Okay.
А скажіть, будь ласка, що було підставою для зміни адреси?
What was the ground to change the residence from Sumy to Poltava? As I'm looking through your documents, that is on the reverse from Poltava to Sumy. So the residence address changed. The reason is, the matter is, the office in Poltava tried to open a law firm or attorney's firm. And a colleague of mine tried to do it. He had attorney's license, and I cannot give information regarding Poltava, in fact. Okay, that is clear. Sergey, Ivan, good afternoon. I will have a couple of questions. So when you answer the question about the failure to declare your wife's income and monetary assets, you said that in late 2024, there was 54,000, of which a big amount was received from the mother. How did you spend that money? It was just to satisfy the everyday needs. It was, in essence, a monetary assistance, but you didn't use it. No, back then, no, because we decided that because it wasn't on a bank account, may it stay there, but there is devaluation. Yes, but the specificity of our region, you don't know in which form you are better off keeping your savings, your assets. When did you receive this money? How long have you kept this sum? The transfer, just approximately. In September 2025. Yeah, September 2025. I see the Public Council of International Experts asked me to provide some proofs regarding that. So you're talking about 2025 or 2024? 2025. So she received it in 2025. And you didn't show it in your monetary assets. But why did you fail to indicate it in your income? Because it is a gift, essentially, from her mother. And I'm asking, maybe it was a payment, but you're saying that it was a gift. So isn't it income? Why did you fail to declare it? So as to monetary assets, we understand that it didn't exceed the threshold, but in terms of income? Well, I didn't realize that it could be income in this case, because it is money, passive money, in fact, a gift. Yeah, essentially, it is a gift from her mother that you fail to declare. Yes, indeed, I failed it. But given from your looking at your declaration, you don't declare movable property or wife's income, and then during the interview, we find out that you use the apartment, that you registered the car. Yeah, I took into consideration my previous mistakes, and in 2024, 2025, your wife doesn't have income, but whereas in fact she did have some income, and you're not declaring your vehicles, and there are violations related to the vehicles and criminal case against you. So it means that you have approached your declaration not really conscientiously. So this is my first experience filling out a declaration. I did not intend to hide anything. And regarding 2025, yeah, 50,000, I failed to declare it because this is an income that she got, a gift. Yeah, indeed, I needed to declare it. PCIe members, any questions?
Про декларацію. Чи є питання вже, да? No, thank you.
Is there a question?
Добре, пане Сергію.
Sergey, over to you.
Практичному завданню хотів поговорити.
And regarding your practical assignment, first assignment, if you recall, failure to declare, and there was a situation when at the time of the offense, the norm of the version of the norm was 1, then modifications took place, and then the threshold of punishment was increased, but you reflected it in the task in a way that the defense attorney drew the court's attention to the need to apply the norm of 2021 when the offense took place. So I'm not challenging your evaluation, and your score is minimal for this assignment. But why didn't you take into consideration the defense attorney's arguments? Unfortunately, I don't recall this assignment because I was stressed and I didn't recall. But Article 5 of the Criminal Code, I recall it. Now I understand that I should have acted differently and apply the norm that was. Well, the issue is different. The judge may make a mistake. The thing is that you did not respond to the arguments of the defense attorney and how you motivated that. It's not clear why you did it, because your decision needs to be motivated even though it is erroneous. So thank you for this observation. This is a very relevant remark. I can tell that I have made a mistake. Please. One more question to you. We can come back to Article 130. You are saying you were taking a certain medication. It was in the form of a spray. So in fact, it was caused by your intake of medication. Is this correct? Yes, it is. Could you tell me, are you being honest with the Commission? I'm trying to be honest always. Then in such a case, everyone's present here, whether you have read the instructions, whether to that medication, that intake of the medication produces intoxication effect. I know of the prohibition to drive. I'm asking you whether you knew that that medication caused intoxication. Why are you saying that the commission got the state of alcoholic intoxication from the medication? I didn't feel intoxicated. I was aware of my actions and I wasn't drunk. I wasn't intoxicated. Okay, clear. Did you file a claim or did you ask for clarifications from the enterprise that manufactures that medication? No. At that time, I was a beginner lawyer and I haven't yet developed a habit to file claims in such situations, such things. Well, you're an academician, you're not a lawyer. We're not talking about a beginner or lawyer fresh from school. So you didn't do it, and you insist on not being intoxicated before the commission. Yes. Okay. Thank you. No more questions. All right. Ivan, you've got 1 minute to address the HQCJ and PCIe members if need be. But please be laconic. Thank you, HQCJ members and PCIe members, for your time, for your for this opportunity to exchange with you. This experience is a positive one and a big one, important and responsible for me in my professional life. Thank you. Thank you for your participation in the interview. Stay well. The interview is completed. We have reached the end of our agenda for today, and the special joint session